Guys, good morning. Today's BrokerCast will be me again, no guests. And today we're going to talk about a few things that have been changing and that you need to implement. I want you to understand one thing. I'm not giving legal counsel any way, any reason, any to you, to your clients. I'm just trying to, and I'm saying this because I go through a few things that have been changing in the law in New Jersey regarding the real estate, the NAR, or what's happening with the NAR. So the New Jersey come with a few changes of their own, and they mandated by law. So it's a lot of things. I'm not going to talk about everything, and this is very authoritative wording. So I'm just going to focus on a few points that is essential, that's new, that's essential, that's very important for you to pay attention. And I don't know if you remember a few casts ago, BrokerCasts ago, I did spoke that as the NAR, it will be coming in effect, everything's going to come in effect on August 17th. And I say that us as the company will start on August 1st. So guess what? Our governor actually have the same idea than me. So in New Jersey, all these things that I'm going to talk about today, they will be coming in effect August 1st, guys. Be careful. It's very important. It's the law. All right? So I'm just going to over a few things, speak a little bit about it, make sure that you guys understand it. You always can search for Real Estate Consumer Protection Act, and you can go ahead and read all these. I'm just going to check a few points. I took notes of a few already that I want to talk more in deep about it. I just gonna, on this document, I go to 2 pages in here that is very important also. On first one in here, we have on section 2 of the law, and that's something that I've been telling you guys since day one, that we should do when you have a listing. And attention, guys. I've been, as New Direction Realty, say that and teach the best that I can, all of you to be doing this. Some of you do it, some of you kind of forget it. Now, it's law. And what it is. So, in here say about, it's about offers, and decide, unless otherwise direct in writing by the principal to present all writings offer, and counter offers is the timely matter. So, what this mean? Timely matter is a 24 hours. So, if you're a listing agent, you have 24 hours to present your offer. That's what they asking for. If not, you have to have something in writing by your seller. So let's say that your seller say, listen, I'm just going to look at the offers 5 days from now, or on this date, or on that date, or just on Mondays. You got to have that in writing by your seller. Okay? So if not, if I send you an offer as a buyer agent on a Saturday, you have till Sunday. You have to present that offer Sunday, but let's say Monday. But if your client actually say, no, I just review offers on Fridays, so you have to have that in writing and let me know that. Okay? So it's very important. Now, keep going. In a time and manner according to the applicable law, of course, that's what I just talked. And. That's very important part in here, guys. I want you guys to understand. I've been trying to enforce this in office forever. You guys kind of don't listen to me. Try that this as a joke. That's not. It's very important. And right now, it's not only me. It's actually written here on this new law. You have to provide a written confirmation of receipt to the other party. All right? So, meaning, that document that we have in our brokerage is there for a reason. Till now, was because I think that's the way we should be. That's the transparency should be. Right now is because it's the law. So, guys, one thing very important. If you're a listing agent, every offer that we have, we have a document on our dot loop, on our debt. You need to fill it up. Have your client take it with you when you present the offers. Have your client sign it, say that they saw the offer, they accept it, not accept it, they're going to offer. Whatever it is right there on that document. Anything that you can do now is mandatory. All right? And if you not accept my offer, your client will sign, say, no, I don't accept your offer. And you send that to me. So I know that you presented. So right now, guys, we have to provide the written confirmation of receipt to the other party. Very important, guys. Very important. So we need to stop playing as realtors and start out as realtors, okay? Now another thing that I want to mention in here, and that's the last thing I'm gonna do specific on the paper. We're gonna be back on the notes that I took more that we go a little more over. Is something in here, and because I know a lot of people asking for, on the commercial properties, you gotta be broker service agreement should not be required between the broker firm and the buyer in a commercial real estate transaction. All right. So right now we talk about the buyers and the broker's agreement as an agent and the buyer. That be 4 families in lot or less, you consider residential. So on that one, it's mandatory we have a buyer's agreement before we show the house. Before you show any house, you have to have that. It's mandatory, guys. But for commercial, so meaning 5 or more vacant lots, big commercial properties, all of that, you don't need it. Okay? We keep going out that well before. All right? It's a lot of other things in here. A lot still. So, guys, I will post a link. If you guys want to take a little better look at these. But if you search Real Estate Consumer Protection Act and Enhancement Act, you can look for it. I think it's somewhere near the name of the number of the ring. It should be somewhere. But yes, if you search for it, new laws on New Jersey, Real Estate New Jersey should be able to get these. And by the way, all of you receive these as an email. So if you look at it, you can see it. All right. Now let's talk a little bit about, and excuse me a second. About some changes on it. And as following up NAR, I took these actually from NAR, is 6 points that's 6 major changes actually on the law. So I just put it in here. We're going to talk a little bit about it. So the first one is seller must, and that's very important, guys. We know that wasn't mandatory till now. Was very recommended. And if your seller say no, you can have a letter saying no, which is seller's disclosure. As of right now, full completely property seller's disclosures must be signed by the seller. And if the seller for some reason say no, whatever you think, you make sure that they understand it's the law. He has to do it. Now it's the law. So guys, if you're going to get a listing, you make sure that part of your paperwork is the seller's disclosure. And till now, you kind of let it be with your seller, let it fill it up what you need to fill it up right there and then. All right? Make sure you bring that with you. Make sure you upload that to the MLS. Okay? That's one of the first points. Now, I'm sorry. Another thing that changed on a law was something called designated agency. Okay? What's designated agents do? So till now we have transaction broker, buyer's broker, and seller's broker, and dual agency. So on a dual agent, for example, you yourself, if you have the listing and you have the buyer, you represent both at the same transaction. It's still available, it still can be done now, but they come up, was already there, but now it's more specific on the law. You can actually, if your seller say, no, I don't want you to represent the buyer, because if you're going to represent the buyer, you're going to have my best interest in mind. And kind of true, if you represent the seller and the buyer, You want the best interest for the buyer and you want the best for the seller? Yeah. How you get that done? Nothing possible, but it's a very tiny line. So what the design agency does is this. I'm working as a seller agent, and that's how I have the buyer. So what happens is my broker will design will appoint another agent from the brokerage to be the buyer's agent. So I'm the seller agent, my colleague is the buyer agent, and we're going to fight for our clients. I'm going to get the best for my seller. My client is the seller. You're going to get the best for his client. That's what is a designated agency pretty much means, okay? Now, I think we go over this already, but it's the point 3, all and all. It's very important, guys. You understand? All. It's not multi-Russian guys. It's not searching guys. It's every single real estate agent will be required to use brokerage agreements. Okay? So, broker it between you and your buyer. Because between the seller you already have, right? You negotiate the commissions, you have the commission agreement. But between from right now, from August 1st, guys, I can say this too much. So you better start today. You better start today. You have a few weeks to it. All right? August 1st in New Jersey is mandatory. Yes, you're going to hear that NAR said that is on the 17th of August. But the law in New Jersey says it's the 1st, and that surpassed any NARs, okay? So what these do, they provide outline service they will provide to our client over the course of a representative transaction. So on that, you're going to say, how much are you going to pay you? What are you going to do for them? What do they have to do for you? And all of that. That's to be signed before you show any property. All right? It's very important that you start to get used to that documents, that you start to do it. Do not delay it. Okay? Now, the point 4 is sellers agents can no longer disclose, so we talk about these, the compensations on MLS or even notify the MLS about cooperative compensation, okay? So, meaning, the contract will be changed. That form that we do with the is going to be probably changed. You cannot disclose anything on MLS, neither in any website that's linked to the MLS. So we know right now we put the listing on MLS, and that listing go to Zillows, Trillos, Trulius, Trull, all of those true things that are out there that you appreciate because our listing get into more hands. But one thing is, you can, as of today, and I believe that this is going to change, you can go to the Zillow, for example, and change whatever appears in Zillow. If you don't do nothing, it appears exactly like it's on MLS, but you can go there and change. Remember, guys, even though that the compensation cannot be posted on MLS, you cannot go back and Zillow and post it there because it's connected to the MLS. So anything that receives information from the MLS cannot have the compensation. So what's going to happen? You as a listing agent, you're going to receive a lot of more calls. You need to get used to grab that phone and explain to the other agents that's going to be calling you, asking if you offer compensation or not, and discuss that over the phone, over text message, over email. It cannot be public. All right? Public, anything related to the MLSs. If you have a website that does not collect MLS, as of now, and understand, guys, everything is changing day by day still. But as of now, for example, on your personal website, you can do it as long as it's not attached any form to the MLS. So if the MLS is sending information to your website, like we do, for example, with our website on KiwiCore, that anything that you put on MLS is going to shoot to our KiwiCore, to our website. So on that case, we cannot put the compensation there. But if you have a private website, a private Facebook page that doesn't receive data from the MLSs, yes, you can do it there now. Again, for now. So I don't know if anything's going to change in the future or not, but for now, it's good. Point 5. And they talk a little bit about continuing education. So it's now a new class that is mandatory to do which is agency. So make sure if you guys do your continuing education online, make sure you choose 1 hour is 1 hour of agency, of course that agency. That's part of the mandatory courses that you have to take now for continuing education. Okay, now go to the last one. And this one, actually, if you see the email from the NAR, I actually took some of these from the emails of the NAR, so I can explain to you, because most of you already do. You don't even look, or you delete it. But if you actually look at the emails of the NAR, this point that I put on number 6 is kind of number 2 and number 3. I just put it at the end because I want to talk a little bit about it. And this is go directly to the listing agents and the open houses. So start August 1st. You need mandatory to state who you represent. Actually, New Jersey created a form that you need to be placed on your visible place on your open house. So when we do an open house, what we usually have, we have a sign-in sheet, you have a place where you have your cards. Now you need to have this form, this there, find some things that you can stand up, put it there for everybody can read it. That's mandatory as of August 1st. Guys, so what he's saying here, attention prospective purchasers, please read these, sign careful. So this signage needs to be there. If they read it or not, then it's not to you, but it needs to be there. This is to advise you that the event, the agent who is conducting this open house represents the seller and is required by law to promote the interests of the seller. Any information you give to this agent is not considered confidential. So that make the people that walk in your house, that if they're going to tell you something, you're going to say that to your seller. If they just walk in and they say, listen, I love this house. I know they're asking 5, but if I can go up to 6. That's something that you can disclose to your agent. So you are all right. Tell them that. You tell me, I'm going to tell them. It's up to you, right? Under international law and the New Jersey law, and could be disclosed to the seller of this property. So you as the buyer are entitled to have someone represent you as a buyer's agent if you are interested in this property. So that means that if they have already signed a contract, even if they come alone, they already signed a buyer's agreement with somebody else. They have they are entitled to have that person entitled. The duties of the buyer's agents include helping you avoid the property, prepare an offer and property and on the property, and negotiate it in your best interests. So you are telling them already that it's better for them if they have another agent, right? Pretty much that's what they say. If you as a buyer are already exclusively represented by a buyer's agent, you are required to disclose this presentation on the signing sheet. So guys, it's very important. I keep asking this. Anytime you should ask everybody that come in at the open house if they have a representative, if they have an agent, and put their name and information on a sheet. Till now, we just kind of, all right, if you have it, please do it. Now it's required. Explain that to the person that walk in. Now it's required. I represent by somebody. Please, I need this information. Put it on this sheet. Excuse me, guys. Now, if you as a buyer are not already exclusively represented by a buyer's agent, please be advised that the open house agent is not precluded from being the exclusive dual agent or designing agent and can enter into a relationship with you as explained in the consumer information sheet. So that means that if somebody walks into your open house and they don't have a representation, you are explaining to them right here on the last paragraph that yes, they can use you as a buyer's agent also. So you can be a dual agent. So this is very important. And guys, remember this is law now. You need to have these on the open houses. One thing that I'm pretty sure that's going to happen right now is going to be a lot of people looking around. There's going to be a lot of, oh, the law is this, the law is that. I don't know if they're going to walk in some open houses or not, but it's the law. Make sure you cover the law. So, as you can see, is nothing in here that it's, oh my God, everything's gonna be done. No, there's nothing in here that's saying that's gonna be a problem. It's just some new rules that you need to implement. Some of those things in here, like the knowledge of the offers that you as a listing agent has to do now is the law, but it's not new. It's something that I've been pushing you guys to do forever. So just pay attention to these little things, these little details. It's very important. So right now, remember, guys, once again, as a buyer agent, the first thing you need to do is have a buyer agreement with your client. You cannot show a property without that. All right? As a listing agent, make sure you have a full, complete property condition disclosure. All right? It's not like before. Can do it today, can do it tomorrow. No, you need to post it right away. As soon as you sign that listing, your client needs to sit down with you and go over and make sure you fill up everything as the best of that knowledge. All right? It's mandatory. Buyers agreement. Sellers disclosure. Two very important documents need to be done right before you post the listing on MLS, right before you start showing houses to the buyer. All right? As a seller, again, open houses needs to have a sign visible. You cannot hide these. You cannot have these and put it there behind so nobody can see it. No, it has to be right there where everybody can see it, everybody can read it, everybody understand it. Okay? Again, listing agents. You have 24 hours to show your offers. If for any reason your clients say they just see the offers in a specific time, in a specific days, you need to have that in writing. And another thing, when you show that offer, make sure you sign the form that your client saw the offer, and whatever, you accept it, not accept it, you can offer, whatever it is, we have that form on that loop. So guys, a few things in here. A few things we are trying already to have been doing on our agency, New Direction Realty. And some of you actually implemented, some of you don't. As of now, by the state of New Jersey, you have to do it. I didn't tell nothing to the governor. They come up with these by themselves. But yes, understand that right now is the law, okay? And again, not August 17th, will be August 1st. I think I go pretty much over everything that I want to go over today. If you have any questions regarding these or any other matters, please reach out to me, text me, comment, ask on a YouTube chat, on a YouTube on a video. Please, again, I'm not tired to see these. Remember, I'm not give you legal advice or anything. I just tell you what it is, what's mandatory or not. You can feel free to consult this New Jersey law. Everything is there for you. If you look at the NARS emails that you'll be receiving, all this information is there. So just inform yourself, and remember, August 1st, that's the deadline. So before I'm going, guys, thank you. Please watch the YouTube videos, watch our BrokerCast, subscribe us, like us, comment, do what you have to do. You know what to do. All right, guys, see you next week. Thank you.